I've asked majority of the questions I intend to ask, although there are just a few questions that I have to ask as the court pleases. I didn't, I wasn't even aware there was a benchmark, there was a cap. My noble lord, I'm not even aware that my noble lord stated that I had just 10 minutes. In fact, even at the last date when we came here, it wasn't even mentioned. In all fairness, my noble lord, in all fairness, I'm just hearing that for the very first time.
Okay,
That's
what happened. So now, you're speaking from the bar. How many questions do you say is still out?
My noble lord, I have a lot of questions, but I don't intend, I won't be asking all the questions I have here. Okay. I won't be asking all the questions.
Okay, let's what's this? It's almost 2. Okay. Let's give you 10 minutes past 2 or 2:15.
15 minutes should be enough, my noble lord.
Okay, it's a minute. Yes.
As a copy, it's fine.
You can even stop before the time I'm talking about.
As the court, I just hope that the network will allow us to proceed.
I'll say amen to that.
As the court.
So let's start.
Mrs. Shadiat, are you with us?
Yes, I am. Good afternoon.
Good afternoon, madam. All right, so my noble lord, I would have to start from where I started the last time because of the network issue.
So, you know better.
As the court, please. Now, Mrs. Shadiat, do you have before the court a report that details or shows the panelists and the investigation they conducted regarding the claimant's complaints?
I don't.
You don't. Now, do you
sorry, that was a double-barreled question. Please, just answer one after the other.
Okay.
It will let me write.
Okay, so do you have any document that shows the panelists that conducted?
Thank you.
The panelists that investigated the claimant's complaints?
I don't.
Okay.
Now, do you have the report of this panel before the court?
I don't.
Yes.
Now, do you confirm there was a panel in the first place?
Yes. Yes. Can I give some context to that?
You know,
yes, there was a.
No,
my lord, please, can I?
If she can confirm if there was a panel, and she has said yes, there's nothing more. That is
Can I give an explanation to that, my lord?
You have answered the question.
I need to give an explanation to that.
This was one of the issues we had at the last adjourned date, and I think the witness does this deliberately, knowing I have limited time. When I ask a yes or no question, she takes her time and begins to explain, and this explanation at the end of the day will not even fall within the needed question, the needed answer for the question. The question is simple. Was there a panel? She said yes. What more does she want to say? I've not asked any question more than that.
You make your request, sit down, allow the court to decide.
Now, Sadiat.
My lord.
Please listen. At this time, the counsel that is asking you a question is the one that has the right to ask you questions that will affect his case. And he has this time, it is his own. So that means whatever question he asks you, you will answer him. Don't bother going to expatiate on it if you are not allowed by the court to do so. It is not every case it's not every question that has a trap behind it. Just answer what he asks you. If he tells you to say more, you say more. And if the court wants you to say more, because the court really has to understand the case herself, you can say more. So you have answered the question that
was there a panel? She said yes. That's good as that.
There was a panel. So
now my next question now is, do you know Mr. Ose Okpeku? Ose is spelled O-S-E. Okpeku is spelled O-K-P-E-K-U.
Just to clarify, my lord, the panel that he mentioned was after Joy Table has resigned. Just to make that clarification, the panel he mentioned was after Joy Table has resigned. You know, when Joy Table made a claim that she was victimized by an individual, which is Bola. So that's the panel she is speaking about. And yes, I know Ose. Thank you.
So your answer is that you know Ose Okpe.
Yes, I know Ose.
Ose Okpeku.
Okay. Yes.
Can you confirm? I didn't get her answer, my noble lord.
It is that she knows Ose.
Oh, okay. Okay, yes. Can you confirm that Mr. Ose Okpeku is a partner at Law Crest LLP? Law Crest LLP, the firm representing the defendants in this matter.
I cannot confirm that.
Okay, let me assist you.
Lady say, Ose Okpeku is I confirm that. No, I cannot confirm that Ose Okpeku is a partner. Did you say
a partner? Yes, a partner at the Law Crest LLP. The Law Crest LLP. That is the law firm. The law firm representing the defendant in this matter.
She says she cannot.
She says she can. But I want to assist her. There is a document they attached to their process. Please, I would like the witness to see this. Show her. This part.
It's strange. That's how does it putting her inside his pocket and bringing her documents that have not been tendered before the court.
Well, it is their document. It is their document. It is their document.
It is not procedure, not known to law.
Why is it not known to law?
As regulatory, that can even sign the secret court cases. When you cross-examine a witness, it is not your time to start to tender all your documents.
It is her document.
If you didn't do that and you want to tender it through an advanced witness, there's a procedure to follow.
Oh, my noble lord has said that if there is any objection, it can be
not at this time.
No,
it is at the time we are one part.
Please take this as well. Please take this as well. Please. My noble lord, we are putting this document, my noble lord, we point to the fact that Mr. Ose Okpeku is a partner in the law firm of the counsel representing the defendants in this matter. So she cannot deny knowledge of Mr. Ose Okpeku. And it is their document. This is not a new document, my noble lord. It is a document, part of the emails they front-loaded before the court, but they have refused to tender it. So we are now tendering it through their witness.
It is not like that. See, you can, in your final written address, you can go to town on that. You can really explain it.
As the court pleases.
Yes. But now she has said she doesn't know. She cannot confirm that Ose Okpeku is a partner at
the Law Crest LLP.
That is her answer.
As the court pleases.
Yes. Even if you see, even if you give all this, she may take our time and read it from now to 4 o'clock. She will say she doesn't know about this, doesn't make any difference or anything. So don't, in your final written address, you address this.
But my noble lord, there is a need to, why they need to tender this document is to
it's not going in now. Is it going in?
Because I want the document to be shown to the witness. I want the document to be shown to the witness.
Yeah, for the Claimant
I'm
or
for the
defendant?
claimant. I'm for the claimant. I want this document to be shown to the witness, the defendant's representative in court.
I continue to object to this current procedure. And if my counsel insists, let me verify into
I wish it was tendered through your witness.
decisions of the Supreme Court on the matter. Yeah, it's a special procedure. We learn every day. On the last day, I nearly almost provided guidance when I was able to almost tender. But there's a procedure to follow. And even
I think we've gone through this before.
Yeah, my noble lord, we have followed the procedure, my noble lord.
Document for my own file and be showing to the witness and determine without no foundation, without even the witness taking ownership of the document. Because the examination will turn into a different entirely.
My noble lord, the witness does not need to. It is part of what the defendant front loaded. The defendant is the company, and there's a representative of the defendant in court. The defendant attached this document as part of the document the defendant will be relying on in this matter. What we just want the defendant to do is to identify it as one of their documents, and then we'll put it in. And it accords with the procedure. We are not dumping any document before the court. There are specific questions that will be asked in relation to these documents. It is not our document. It is the defendant's document. They brought it. Why, my noble lord, there would not have been a need to go this route. My noble lord would recall, and I'm just saying this off record. When this question was asked at the last date, the witness answered yes. I repeated it, she answered yes. All of a sudden, counsel stood up and stated that the network was bad, that that he could not even hear what the witness was saying. When I now repeated, no, counsel, please, apologies, no, please, just hold on. My noble lord, when I asked that question again, I repeated it. All of a sudden, she started asking, my noble lord, we are going to apply. No, I'm coming. I'm not done yet. I'm not done. Let me finish. When I'm done, you would have your time.
Say that I stood up and said what was bad, as if I was the one who interrupted that proceedings. But what actually happened that day was network was bad. We were not hearing the court. He was not hearing. My lord was not also hearing. So now in putting that I'm the one that said, oh, we must stop, network was bad. That was not what transpired.
My noble lord, we are bringing in this document to expose that the defendant cannot. This is the defendant's document. Mrs. Sadiat, if we look at the document, her statement, these documents, my noble lord, form part. If we look at the documents to be sought to be relied upon by the defendant in this matter, this document, the two emails, my noble lord, are part of it. So how can she now say, inform the court that she does not know Mr. Esowe, whereas there is a document that the defendant has brought before the court showing that Mr. Okpeku is known to the defendant. As far as I'm concerned, my noble lord, she is the defendant in this. She is the face of the defendant in this matter.
You know what I'm just saying? The only thing I'm saying is this, because I cannot descend into the arena, is that she said, I know Mr. Esowe Okpeku. Now, for her to confirm that Esowe Okpeku is a partner at the Crest LLP, it's what I cannot say, because what if she knows the man, she doesn't know that he's a partner in somewhere? Counsel, see, these are things that you can,
as the court pleases,
take up in your final.
I hope, my noble lord, I still maintain that there is no law that does not allow a party to tender its own document. It is, if it were to be my own, the documents belonging to my witness, it would be a different thing. But this is the defendant we are talking about, and how can I know? The law permits me to tender the defendant's document through the defendant. This is not my own document. This is not the document belonging to the claimant, but the defendant. So there is no law whatsoever that says if counsel can provide that law, he has been citing Supreme Court, let him provide it and let us see it.
For tender counsel to read, have practiced over 20 years.
No, you provide it before the court so that we'll see it.
I don't see that. I take most of them and incorporate it in my own practice. I report my law to Korea and State 2023. Law Pavilion and Economic Law is what 59975 Supreme Court. Page 9 to 10. Paragraph C.
Let me put it, is it on record? Otherwise, please let me put it down.
No, it is allusion that is not the law that maybe it's here.
Yes, I still want to know the case.
Yes, my lord. Okoko Lie against state 2023.
Okolia against who?
State.
Okay.
There are many decisions on there, but I'm giving you the latest one. 2023. LPELR
Yes.
59975 SC.
Yes.
At page 9 to 10. Paragraph G to D. Essentially, the Supreme Court dealt with
Yes.
conditions under which you can tender a document during process examination.
Okay. So can you quote it for us? Can you quote them?
Yes. Okay, part of the decision says it is obvious from the clear wordings of section 3232 of the Evidence Act that it requires that before a previous statement of the witness can be admitted to evidence for you to contradict him under cross-examination, the witness' attention must first be drawn to the parts of the statement intended to be used. Once this condition is satisfied, the previous statement becomes admissible for the purpose of contradicting the witness on the material fact. To determine if this foundation prescribed from 232 of the Evidence Act was laid before the defense applied for the admission of PW2 statements as evidence, recourse must be had to the cross-examination of PW2 before the said application was made. If you read the facts of the case, the Supreme Court was saying, when that issue of whether it was properly admitted or not, say, look at the cross-examination on the questions asked. It will be obvious whether the provisions of evidence have been satisfied and the foundation necessary to tender the document during cross-examination has been laid. So the question my lord will ask in this instant case now, the document my learned friend want to tender, if my lord looks at the questions he has asked this morning, has he laid foundation for that document to come in? What I had is, I have two documents I want to show the witness. The other addresses he's making before my lord, they are their documents. They predate it. It's just coming now. It is neither here nor there. My lord will have to look at the questions he has asked before now, and the Supreme Court has said to find that foundation in the questions and answers elicited from the witness prior to tendering that document. He has not done that. And it will be nice, maybe if you take time, read the case, digest it. It might not be for this occasion, but for other occasions, so that you do the proper thing.
My noble lord, may I point out that based on what counsel read, it says statement. Even from that alone, I can say that that particular law or case law does not apply to this very situation. That does not mean that I'm going to read it. I'm going to read it, at least to understand other things that the case is all about. However, this is an exhibit, not a statement. And counsel cannot say that I've not laid a foundation. I have asked the question, is Mr. Esowe a partner in the Law Crest LLP, the law firm that is representing the defendant in this matter? She said, I do not know. And that is the foundation I have laid to bring in these documents. Upon showing her these documents, there are some questions I would ask in relation to this document. The foundation has been laid going by that case, but I still insist that that case law does not apply to this case. This is not a statement. This is an exhibit, different from what that case is about.
The only option actually for you to tender a document to an adverse party is that the document or statement emanates from that person, and we are using it to contradict the person's previous position. So whether I call it a statement, whether I call it a document, his position is that the document must have been introduced to the witness. From what he said now, he asked me a question, I said he don't know. And he said the foundation has been laid. That is not the essence of the foundation. The foundation is actually to lead that witness to that document.
Okay.
But my noble, I believe I've done the proper thing to bring in these documents, and I think it's best to proceed at this time.
I just went back, through my records.
As the court pleases.
I saw some, let me read out what I saw now. I don't have any document of of the details of the panelists and the investigation they conducted regarding the claimants' something. I do know Mr. Osi Okpeku. Yes, I do. I confirm that this person is a partner in the law firm representing the defendant in this matter.
This matter, as the court pleases.
I confirm that he was a member of the panel that investigated the claimant's complaint. I cannot confirm that. I know Omabo Yode, somebody, Ochilola, a lawyer in the law firm representing the claimant. So what you're asking her now, has she not answered it before?
Yes, at that date, Manopo will say that the response here is that she knows that Mr. Osi Okpeku worked with, is a partner at the law firm. At the law firm of the counsel representing the defendant in this matter. Yes. But now she has changed it. She has given a different response.
What did she say?
The response she has given.
My Lord, kindly allow me.
If my noble can go back to her response.
My Lord, kindly allow me to give some context.
These documents. I asked her a question. I said,
let me see what she wants to say. Let me hear what she wants to say.
Okay.
Yes.
My Lord, like I mentioned before, I know Ose Okpeku.
Yes.
If Ose Okpeku there's a description he made about him that I cannot confirm. But knowing that name, yes, I know that name. The position in the law firm, I do not know. Also, in this matter, he has never appeared in court. He has never appeared in court on this matter. Is our counsel that is seated there that has always appeared in court. So I need to give that clarification, my Lord, because this counsel is fond of trying to put words into my hand, mouth.
My noble Lord, the question I asked her.
My Lord will give that.
The question I asked was he a member of the panel that determined the claimant's complaint? And then she said that she does not know. If my noble Lord goes back to the previous, my Lord would see that her answer was that yes, that he was a member of that panel. So all we just want to do is to discredit her, that she is the face of the defendant in this matter. The defendant cannot say, I do not know somebody that I appointed to investigate a matter for me. She is the face of the defendant. The defendant cannot. No, we will, but we need to put in these documents. It is important, my Lord. We have laid.
My Lord, attention to the time.
Of course.
Okay, that's very important.
He's the one making address.
They have refused to allow me progress. This is what played out at the first time we came for this matter. Each time a question is asked, it will be dragged and dragged. All I wanted to do was to put in this document, and the law permits me. There is no law that says this document cannot be tendered through, my Lord, section 4 of the Evidence Act that talks about relevance. This document is relevant, my noble Lord. It is relevant. It is the document, the defendant's document in this matter. It can be tendered through the defendant. If I cannot tender the defendant's document through the defendant, then who is the person how can I then bring it before the court? he has cited a case which talks about statements different from exhibits before the court.
Okay. Actually, there's still, is there any other case before the court today? I cannot say what is documented. PIP was specifically implemented. There is nothing to show that there was no PIP policy. It's to the documents. The minutes of the meeting. Documents to show that I showed my colleagues to the company staff and incorporating the PIP. It was not mentioned in the staff handbook when Clemens was told about. Now, apart from tendering this document through this particular person, is there any other way you can bring it to the court? I mean, for the court to know, bring it as an exhibit. Is there any other way you can do that?
Manu, this is the best way I know I can do it at this stage, because we have already concluded, we have closed our case. We have closed our case. They have just opened theirs. And when the defendant was tendering some documents, we observed that the defendant omitted some documents. The defendant omitted some documents. Can I conclude?
Just proper that you tendered all the documents, like what is like that we have closed our case.
No, I'm saying that the claimant.
Is it after? Yes, you claimant, you have closed your case. After closing your case, you start to introduce new documents at the stage when you already cross-examine my witness.
Manubulot, for the purpose of continuing, Manubulot, can we put in these documents and let us address it in the final written address? That is the best thing, because I know that there is no law that prevents. No, I'm coming. Can I finish, please?
The way it keeps saying, can we just put in this?
Yeah, Manubulot, because we have to proceed. This is the defendant's document, and from what he read, which I know is not on all fours with the facts in issue, where the defendant witness has made a statement which is not true, I can bring in a document to discredit the testimony of that witness. The witness has informed the court that she doesn't know whether Mr. Esowe was part of the panel that sat on that matter. And moreover, there's a document from the defendant that speaks otherwise. That is all what we want to do, to bring it before the court. We have asked a question. She has misrepresented the actual facts. Now we want the true position to be brought before the court. That is all we want to do and nothing more. And we can see how the defendant is fighting tooth and nail to ensure that this does not take place. It is because there is a clear understanding that this document speaks contrary to the testimony that the witness has given in court today.
That document, is it before the court?
It is before the court, Manubulot.
The one that you're talking about?
Yes, it is before the court. It is part of
the one you want to show her. Is it the one you want to show her?
As the court pleases, yes.
It's already before the court?
Yes, it was part of the document they served
on
the
you.
defendant, yes, served on us. Yes. That's the reason why, Manubulot, it is their document. When they, I don't want to speak so much so that because the witness can hear me, I don't know, let her not preempt my other questions. But this document is from the partner, Mr. Esowe, who is the partner in the defendants, in the law firm representing the defendant. So we could not have had access to this document. It is that document. If Manubulot goes through the memorandum, the documents attached to the memorandum of appearance that they filed in this matter, Manubulot will find these documents as one of the exhibits forming the bundle of emails attached to that document. It is there before the court.
Okay. So you pleaded it and you front-loaded.
He hasn't.
He front-loaded it.
Yes, it is before the court. It is before the court already.
If you want to address the court in that sense and refer to the documents that has already before the court, fine and good. But what he's trying to do now is not done. And it's not the kind of practice we want to teach to young lawyers who are learning. Okay, they have gone already.
No, they're here.
Find the procedure to do the thing. If you need to go and study it and master it, you do so. And it takes a little bit of doing the proper thing. For a court of record to be able to do his business as a court of record, you can't just say, oh, because they mentioned it somewhere. If I want to tender documents that I have in my custody through their witness, which I did, only one document. He could not even have objected to it because I discussed that document extensively without their witness. In fact, all the contents, I confirm all the contents of the document from her. And I asked her, which is the document, does she know it, and she agreed. So I don't know, I'm doing his case for him now, but it is not just right. You can't just put your hand in your pocket and come up with document and say, show it to the witness first. It is not done.
Okay.
Manubula, I have
No, we cannot go on like this forever.
Manubula,
we cannot go.
I want to ask.
It has taken 30 minutes already.
How could I have taken 30 minutes? I've not even asked any question.
Okay, now, counsel, what I'll advise you to do is this. Since the position in this court is that when somebody has a question, when somebody brings asks a question, as it were, and the other person says she does not, I don't know how we can do this to put this document through her.
I can ask for that questions.
Yes, you can ask other. Let us go on with other things. Then in your final written address, you can address this.
Manubula, if there's a need for this document to come before the court, but we'll get there. There are questions I want to ask the witness.
Since you said that,
if our answers are still at variance with these documents, Manubula, we would need to put it in because a witness can't come before the court and misrepresent facts. That is the essence of cross-examination.
Sure in your final written address, you can put up all this. You can even remind the court that whatever is your grounds now, you can let the court know. Then we'll go back. This is my record, and I believe so much in my record. So I'm going to go through them all, word for word, so I know what said who said what. So,
all right. Witness, are you here? Can you hear us?
Yes, I can hear you, my lord.
Okay. Are you aware that Mr. Esowe Okpeku forwarded a letter of introduction when he was appointed by the defendant to sit on the panel that investigated the claimant's complaint?
I am not aware.
In fact,
sorry, you asked her whether she's aware that the partner,
Mr. Esowe Okpeku, he wrote a letter.
Esowe Okpeku himself.
Yes.
Did what?
He wrote a letter of introduction. When the defendant appointed him to sit on the panel that investigated the claimant's complaint.
Yes.
Now, are you aware that on that basis, Mr. Esowe Okpeku?
No, I don't know what my last referred that answer to the last question.
She said she was not aware.
She said she's not.
That Esowe Okpeku, yes, wrote a letter when the defendant appointed him to sit in the panel that investigated the claimant. Okay.
Okay, now, since you have already identified that you know Mr. Esowe Okpeku, and that also he was part of the team that sat on that panel of investigation. Can you confirm if these emails relate to the investigation conducted by Mr. Esowe on behalf of the defendants? I know, Lord, we would like to show
emails.
Yes, emails. Please.
He has not introduced the document. He's just saying the Senate, just like saying, look at this letter. He has not introduced what that letter is about.
A letter of introduction.
On the witness relating to the contents of the document and the document itself. If you get to the point where the document, the witness can now say, I know the document, we tender it. He has not gotten to that point.
A witness that has come before the court, and has refused, persevered in misrepresenting facts. How can I force that witness? No, when I put in these documents.
Now, if this alter, what I wouldn't know how to describe it, continues, we cannot no more continue with this case. Because yes,
I'm sorry, my lord.
Somebody has to say something and the other one has.
I don't think, with due respect to you, you use other words, but continue saying he has refused, she's misrepresented. This is not how to do cross-examination questions. Even if you feel that the witness is misrepresenting, you ask questions to bring it to the court. You cannot be expressing the opinion disparaging the witness.
My noble lord, all I want her to do is to confirm if these emails, my noble lord, relate to the investigation conducted by the defendants in this matter.
Are these emails before the court?
They are before the court, my noble lord.
As what?
No. It is part of the bundle of email correspondence.
Okay.
That
show it to her now. She may know. And this is the last question, please. Sadiat.
My lord.
Look at the paper in front of you. Then ask her the question.
Can you confirm if these documents, please, there is can you show her the one at the back first? Yes, so that she can see it clearly. Can you confirm if this email relates to the investigation conducted by Mr. Esowe on behalf of the defendant regarding the claimant's complaint?
I cannot confirm, my lord. I cannot confirm.
If you can, my noble lord, that is fine. We intend to tender these documents, my noble lord, as an exhibit, as exhibits in this matter.
I would be subject to these foreign documents produced by the Claimant Counsel at this juncture. But they are not given or thought, they are not documents made by witness. They have not created any proper foundation to be able to tender them during cross-examination, connecting the witness to the documents and the contents, enabling the witness to take ownership of the documents as her own, identifying them for purposes of being admitted. I was that decision of the Supreme Court here and state case recited clearly that counsel cannot just during court examination go to town start to bring documents and tender. Apart from the unfounded allegation that they were contained in a bunch of documents, nothing else was done to lead this witness to identifying this document to enable counsel to tender them during cross-examination.
I'm afraid I agree with this point, because even if the email letters came together with other ones, we cannot just ask an umbrella question that, see, look at this, if you can confirm that this email is part of. It means you have to give her the load of emails, and we will now wait with our answer, Kimbo, for her to see whether this is part of the ones that are ready before the court. So,
my noble lord, I understand that when I tender a document through a party and there's an ambiguity it raises, that ambiguity can be cleared during re-examination. And these documents, even though it is attached to other bundles of emails, my noble lord, it speaks to a particular fact. Other email letters, my noble lord, also speak to a particular fact. The emails attached speak to the introduction of Mr. Esowe by the defendant upon his appointment by the defendant. That is what it speaks to. The second one speaks to the involvement, the investigation that Mr. Esowe conducted.
do you expect her to, just while sitting here, sort out all these things?
It is that document. It is that document. They brought it in. And I believe that when you bring in a document, it is because you have basic understanding as to the document you are bringing before the court.
Mm-hmm.
So that's the reason why I am of the opinion that she already understands this document as well as other documents that she has brought before the court.
You are saying your opinion. What if your opinion is not right?
It is her document, my noble lord. It is her document. She brought it in.
Okay.
And the thing there is, my noble lord, these documents were brought, but the documents were not tendered. Only a few. The defendant only tendered a few. Only a few of these documents were marked as exhibits. So other documents were not. And if we look at their statements, it wasn't as if the documents where the dates were stated. It only states email correspondence on the investigation conducted by so. And there are lots of emails on that subject.
So is it such that we can sort out now?
Yes, my noble, it can be sorted out now. If the court goes through its records, because I've seen the bundle, I have the bundle here. It's one of the last exhibits on that document. It won't take the court's time. It is that document. They brought this document before the court, and all we are seeking to do is to bring it in, since they have refused to tender it, to expose that the defendant cannot deny knowledge of Mr. Esowe's involvement in the investigation conducted regarding the claimant's complaint.
Well, I've written what I heard as a answer. So I don't know. Yes. So what else?
My noble, I want to find out, is my noble rejecting the tendering of the exhibits?
Well, you want to tender it. What we show it to the other counsel.
My other, I've raised the objection. In fact, my one have already taken a position. But my other friend seems to want to overrule your lordship. Because we've addressed the court and the court have expressed a position which he doesn't like.
If it's on the record, it's fine. If it's on the record that it was tendered and rejected, it is fine. We can take steps thereafter. Because I believe that these documents are necessary in this matter. These are documents that are relevant to this case.
Please let me see the documents she said. Document shown to me.
Did not put the dates.
Thank you.
No, what happened?
So the witness.
No.
Denied knowledge. Yeah. Sure. So 6 to 10 or so. Okay. First. So the witness denied knowledge of the two documents shown to her, and the learned counsel to the learned counsel, and you're for the
Claimant.
defendant,
Claimant.
for the
And
claimant.
for the claimant, my noble lord.
The document, the counsel to the claimant seeks to tender the same, and the learned counsel for the defendant opposes the tendering and gave reasons for that. For the court, I do not think enough background has been laid in order to tender this evidence document. The documents, therefore, are hereby rejected.
As the court pleases.
Yes. Yes.
All right.
Sir? No, it was not admitted. It
Now,
can be admitted later, but yes.
Witness. Witness, are you there?
Yes, I am.
Yes. You stated you know Mr. Esowe Okpeku. Can you tell the court how you come to know Mr. Esowe Okpeku?
Counsel, this is the last question.
Honorable Lord,
Yes.
Honorable Lord,
Yes, it has to be the last question.
Honorable, my noble Lord, we can take a date and come back. The issue I have is because of the objection put forward regarding the tendering of these documents.
Yes.
Some questions that I would have used that time to ask, my noble Lord, are still there, and I have not asked them. So far, my noble Lord, I've not even been able to ask up to.
Okay, as for now, today, this is the last question.
As the court, please.
Yes.
As the court.
Yes, please go on.
All right, so witness, can you tell this court, since you already told the court, you informed the court that you know Mr. Esowe Okpeku. So since you know him, can you tell the court how you came to know him?
All right, thank you very much. When Joy Table resigned, after her resignation, she filed a petition or a query against an individual. So that individual is Bola. So after she has resigned, she now filed that against Bola. As an organization, we gave her a fair hearing, even if she's a staff that has resigned. We gave her a fair hearing, and Ose was part of that team as a neutral and independent observer in that committee. So that was how I knew him.
Honorable, can I beg the court for one favor? Just one more question as a result of this, and that will be all for today.
Please, if I don't write down what she said, I'll forget it.
As the court pleases.
Yes.
Okay, now next, considering that Mr. Ose Okpeku is a staff of the law firm that is representing you in this matter, do you think he would have maintained his neutrality in the course of investigating that matter?
That's an opinion question.
Thank you. Thank you, my lord.
Let me rephrase it, my lord. All right, so witness.
I'm here.
Was Mr. Okpeku
Yes.
Honorable, just a minute. All right. How long has Mr. Okpeku, Ose Okpeku, worked with the Lawcrest LLP?
I cannot confirm that. I don't know. I don't have this information. I don't.
What are you
So
objecting?
I can only cancel. I can only respond to information I know, and I can confirm.
What are you objecting?
How long he has worked in an organization, I do not know, counsel.
No, I'm not. No. Don't say that. My lord, you can see what counsel is trying to do. He's trying to put an answer in the. No, I have to because my next question, my lord.
Counsel, I have responded that I don't know how long. I don't work in that organization. So I don't know how long he has worked in that organization. The only time I came about Mr. Ose Okpeku was when Joy resigned. He was part of an independent committee because our organization was a listening organization. Even when Joy resigned, they wanted to hear what our complaint is. And Mr. Ose was part of a neutral observer in that committee. That was the only time I knew about him. If he's the partner, if he's I don't know any other information about him. I don't. Thank you.
The point I'm trying to make is that it is not a law firm, is not a party, and we are lawyers. I don't know.
Are you testifying? Counsel is testifying now. You are testifying. If you are standing up, it is because you have an objection to make, and you are not objecting. You are testifying.
Okay, that's all. That's the defense. That is the questions from the claimant. Yes.
We have one more.
No, my noble lord, we are not
One
done.
more what?
We are not done with the witness yet.
Okay.
My noble lord, we are not done with the witness yet. My noble lord,
Okay.
my noble lord, I mentioned.
Which was the second day?
November 4.
Okay.
My noble lord, in the interest of justice and fairness,
yes,
I think the claimant should be given more time to conclude these questions. In the interest of justice and fairness, my lord.
If I'm watching I'm looking at the questions you're asking and the answers, and I'm thinking, where is this leading us to? Are we going to stay here forever?
No, I'm done. I'm done with that question, my noble lord. I'm done. All we wanted to bring before the court was that Mr. Ose Okpeku was a member of the law firm represent. No, I'm coming, please, counsel. Please. I'm still on my feet. No, but I'm still on my feet.
This you are fit every time you are still on your feet, you are still on your feet.
My noble lord, my understanding of how it works at the bar is when the council is addressing the court, the other council would hold on so that there will be decorum in court. For the purpose of decorum.
And keep listening to you.
My noble lord, the point.
For 1 hour. And if we leave you, continue talking to you tomorrow. My lord, the point I'm making is the length of court examination is not what determines the effectiveness of court examination.
And I've already.
This is the three of court. I cross-examine their witness. I didn't take 20 minutes.
My noble lord, they didn't give us the time. My noble lord, on just 2 documents, my noble lord, we spent minutes on objection. The questions that I ought to have asked, I never asked those questions, my noble lord.
Okay.
So I'm pleading with the court, just one adjournment so that I can round up with the witness. And if they can come with the second witness on that day, we'll continue with that witness. I just have like a few questions.
But right now, nothing is going on again. It's adjournment that
As
I
the court
want.
pleases. As the court
The
pleases.
last line of questions that being asked, an indication that can be posted. Any question that is important.
Dates, please. Okay. Okay, you said 4th of November. So this matter remains adjourned to the 4th day of November 2025 for continuation of hearing. Yes.
For continue of hearing the another witness.
Well, we will continue this case. We'll continue this case.
That the look of the witness to ask to be available.
Eh?
The look of the witnesses to ask to be available.
Okay. How many witnesses do you have?
Just 2. The fourth one, right?
You have 2. Okay.
That one, at this point, is very good.
That's what all of you say.
No,
But
we have just, it's not in any document, we don't adopt a statement on oath. If I don't know how many days I think we need to process any other. It's a short statement on oath, and we're not sending any document.
What questions? The objection and objection that has so much time. And I gave my Lord indulgence to allow us to proceed. You have just to finish more questions.
today,
No, not today.
okay. The matter is adjourned to the 4th of it remains adjourned. It has been adjourned before to the 4th of November 2025. For continuation of this case, when by the time we come here, because I've seen 2 questions answered in 2 different ways. So it means that the court will have to go and read it as if I'm doing the judgment on the next day. So when we come on that date, we say, I think, Council, we've been fair to you, Council. We've been fair to you because you took a really long time with your cross-examination. This is the very last time, and you've taken 1 hour. 1 hour. Okay.
It wasn't like this when the human was given a testimony. It wasn't like this.
I will give my learned friend three answers. When we are asking like what is an interest rate, if the witness say no, you never answer the question. The problem is that when the witness don't answer the question the way they like, he said it. The all is to ask.
Okay. Thank you. Thank you. In fact, I'm not eating it again. Oh, Sadiat, is that the name? Sadiat.
Yes, my lord.
Okay. I have to tell you that today we finish with you today. So yes, you can log out. And thank you very much for being a part of this.
Thank you, my lord.
Very well. Well, call the next one.
Between National Pension Commission and registered trustee of Bogota College.
Please, thank you. You can go. Of course. And I thank you for being part of this court today. Yes, please. Okay.
Your name, sir? Ayo Ogunremi. Your position, sir?
Yes. Appearances. Yes. Come again. I've taken your name before today.
Yes, my lord.
B-Y.
Yes, my lord. Dania, D-A-N-I-A.
D-A-N. Okay.
For the claimants, my lord.
Yes.
With all respect to this honorable court.
Yes.
His name is Paul Mobuti. My appearance is for the defendant. Mobuti spells O-M.
I can spell it. Eh?
O-M-O-B-H-U-D-E.
Okay.
My appearance for the defendant.
Yes.
But the matter was started for defense.
Okay.
This is in court.
Very well.
However, we have a motion.
Filed when?
So it was filed in the 15th of November. 2024. Taking leave to the file of the prison to the next events on roads. Gibson must provide the file.
Also, I beg your pardon. What date again?
18th of November 2024.
18th of November. Okay. Granting leave to the applicants to file an additional witness statement on oath. Deeming order. Okay. Please confirm that you've been served.
Yes, my lord. We've been
Okay.
served, my lord.
Have you reacted to it?
No, my lord. We'll write our reaction at the end of the matter in our final address, my lord.
Oh, okay. Yes.
Subject to the conditions of
Yes.
the seek to move our motion dated 11th of November 2024.
18th of November.
Taking the leave of this honorable court to try the petitioner to the US Supreme Court. I am already.
When did you file it?
The first same day, the 6th of November 2024.
Okay. Council, what I see here is 18th of November.
18th of November 2024.
Yes.
Yes.
Okay. Yes.
It is deposited by, supported by affidavit, deposited by Rashid Tiamiyu. It is 7 paragraphs affidavit. It's one exhibit attached.
Yes.
Line of the apartments, together with the exhibits as evidence. We also filed in line with the rules of this court a written address in support of the motion. It is dated 18th of November 2024. We adopt the written argument given as support of the motion. And we respectfully urge your lordship to grant the application.
Yes. You said you're going to leave everything until your final written address.
Yes, my lord.
Okay.
I don't know if I can respond to that. Procedures of this court. It's a motion. It was filed, it was served. We have enough of this to respond to it.
Well, but what if they don't want to?
If they don't want to respond to it, they submit to it. They've admitted to it. They don't want to. The only way they can respond a court of record is by filing a counter affidavit and written address.
Councillor, I just hope you know that if you do not respond, the court is going to order a spread.
As the court pleases.
Okay. So the application of learned counsel is granted by the court, and the court orders are spread on the motion paper. Yes. Yes, that's the motion.
Yes, my lord. We have subject to, I don't know, sorry to the convenience of the court. But come be tired, we can just commence it. If my lord would not want to go through the rigors of presentation and all that today, we can commence it.
Yes, you have just said it. The court cannot do that. Thank you very much. I cannot go through the evidence in chief, cross-examination, which the person, I'm sure she's the person to cross-examine. She can never finish in 1 hour. So let
As a
us
couple.
just adjourn it to another date.
As a couple, please.
We start it from the beginning and then,
As a couple, please, my lord.
yes. Give me a date.
Okay. My lord, if I may,
Yes.
since their weakness is in the court, he can go ahead and give examination in chief, and then we'll take a date for cross-examination.
You see this woman here?
I understand, my
I'm
lord.
a human being.
I understand, my lord.
I cannot, like I said, I cannot go do any other thing.
I understand, my lord.
Yes. Who is the witness? Yes, I'm happy that you're here today. Your case would have been taken, but it's unfortunate that I cannot take it. So please, on the next agenda, try and come here so that we finish this as soon as possible.
As a couple.
Thank you. It's convenient. He said it's convenient. How about you?
It's convenient, my lord.
Okay. So this matter is now adjourned to the 28th day of October 2025 for hearing of this case.
As a couple, please. Most grateful, my lord.
Yes, very well. And sorry for staying here till the end of the day with that. Huh? Yes, they are ready for defense. For defense. Okay, is that what you mean? Okay. Tomorrow is Lagos State. Wanted not to come to friend.
Where's Mr.
Siraj,
Siraj?
he's not around.
He's not around.
So sorry.
No, no problem. I need to know what's not together.
I just let the clock just rose, madam. The clock just rose. Just have to call me back. Yes, because I thought the court would have risen by then. Because just for something is on me. Just rose, please. Don't give me time. Let me just continue that. Court just rose.
So you're hungry, madam.
So what is happening?
So you want to eat after keeping us here from morning till
Oh, wow.
Me? Okay. Okay, I thought it's not only you, me too. You finished from last one. Okay, I thought you finished. You look familiar, kind. Where we breakfast inside this bag? Where we breakfast? I'm coming from far, so that's why I had to come. I need to cut. I don't like eating money for that. Thank you. You guys took all our days. All day. No.